Hi there. Welcome to another edition of the Author You, Your Guide to Book Publishing podcast. I'm Dr. Judith Briles, and I always love to keep us topical in our now 8 years of podcasting, which is like in perpetuity, it seems. One of the things I love to do is start with a quote from one of my books, the Snappy, Sassy, Salty Success for Authors, which is over 400 of my personal quotes. So I just always open randomly. Our topic today is going to be on the general theme of author success, book publishing success, and getting more smarts. And so I randomly opened it, and here's what popped up. Authors begin to become successful the moment they decide to be. And that really does fit in so well with today's topic, because we have a newbie to the screen with us, an intellectual property attorney who we haven't had the pleasure of working with before we know about, but we've now tracked him down and invited him to be with us for the hour to really dive into the IP world of what's going on with trademark, with changes, especially with the Anthropic settlement that closed out at the end of March. And my disclosure, I was one of the authors that got ripped off. And I decided, okay, I need to get serious. And I know in my newsletter before the end of March, I put out, here are the steps you all need to do if you have not done it. For example, just go, here's the link to the Anthropic settlement claims. One. Number two, here was, so put in your author name or an ISBN of a book. You could put in your publisher. You could put in any of those things to try to let them spider through and see if you're on there. And sure enough, there I was. So the next thing is, you need to file a claim. But here's something. To file a claim, there's something called a unique number. They didn't tell us about the unique number, but there is a phone number I found buried on that homepage of the settlement that said, call us. And lo and behold, no phone tree, no nothing. I got a human being. I was so excited.
Shocking.
And yeah, that epic. That was epic. and I then went in and they said, if it's their name, and they said, yep, we see you here. And then here are your unique numbers for each of your books. And away I went, and in 5 minutes, all the claims were filed. So it was a 1, 2, 3 process if you follow the 1, 2, 3. And that now
Judith, a quick question. What did they say the dollar amount was for your settlement?
They did not respond back with X amount right away, but they're saying $3,000 a book.
So, and was there an option to opt out of the settlement?
Oh, you could. Yeah, you could. I'm not going to diddle around. I am not fighting someone with a massive bottomless checkbook, let me tell you.
Yeah.
I've learned with that. But let's introduce the fabulous Colin O'Brien, everybody. All right. So here we have with us someone who has got over 2 decades of intellectual property experience behind him. He is the co-chair of his firms, and he is based out of Illinois. The firm's intellectual property group. He's a partner within it, and Colin has an inherent appreciation of just the value and the importance of your intangible assets, like patents, like trademarks, like the data, like your stories, your copyrights. And that recognition is combined with his extensive and diverse experiences. So he's an invaluable ally. You all need an IP attorney on your side, by the way. Whether it's Colin, you need to have someone who really has some smarts in this area, and that to protect you, to monetize you, what your portfolio is worth. And one of the things, Colin, I would love to talk about a little bit is about estates and how to handle intellectual property in your estate planning, because rarely do people go down this path. And I think it's really important to do. So welcome to the show.
Well, thank you, Judith, and I'm really happy to be here. And like you said in your bio, my job is to help protect
Mhm.
creators and people who,
Mhm.
companies who create brands and creative people who write books, who are musicians, everything like that. Because the most important thing, my job is to protect assets and protect and
Mhm.
then make sure that the people's hard work are monetized and that the people don't kind of
Mhm.
take it away from them. And it's a very important thing for authors to know. And I've worked with authors in the past, and we kind of talk about like, oh, you have a book. Okay,
Yeah.
what do you do with the
Yeah.
book? Okay, what's the next steps? Like,
Yeah.
what type of book is it? Like, if you're doing a self-help book, it's, okay, well, what's the next step of the self-help book? Because as you know, once you write a book
Mhm.
and you spend all that time and effort and just getting something really great published, you can't just stop. You have to kind of then start marketing it and selling it, and it's you almost have to learn a whole completely different language of your book, and so that you don't want people taking what your hard work has resulted
Mhm.
in. And
Mhm.
we've
Mhm.
dealt with
Mhm.
situations where you know there was a fairly famous doctor. She was out of Hawaii, and she
Mhm.
wrote a book, and she had this whole like, okay, this is how you can kind of live a better life. And she was like, well, I would like to trademark my book. I was like, well, you can't trademark a book title, and
No.
because the book title is just kind of the source of the book. But what
Mhm.
we discussed is like, if you create workbooks that are associated with the book itself, then it becomes a series, and then you can get the trademark for the series of books. And the best example is like dummies for dummies, you know, uh, you
Mhm.
know, blank for dummies, and so that's creating a series. And so she's like, okay, so what we'll do is we submit it to the patent trademark office, the original book, and then we also submitted the workbooks that she had created, and we were able to get a registration for publication of books under this title. And then what she also then did with these books and workbooks is she started creating seminars.
Mhm.
And these seminars allowed her to kind of go and teach people. And then she created a process where people can teach her program. So then he became uh, a certified teacher of her program. And it
Mhm.
all started from like one book, and it expanded out and out. And what she did is like, once you do that, you always have everything, under copyright. And it allowed her to kind of, her life work was writing a book to kind of help
Yeah.
people. And then
Yeah.
she expanded and she created a whole business out of it. And it's exciting when something like that happens.
Yeah. I had not thought about, I'm thinking about my own writing
Hmm.
that I am, people who've been listening to me for a while, I was a reluctant author. I never
Hmm.
intended to be an author. I ended up being an author when a very well-known author ripped off some of my information that he pulled from a dinner conversation and published it. And when his New York Times syndicated column came through, and all my ideas were laid out in his column,
Yeah.
the epiphany dropped in was, JB, if you don't start taking some of your own ideas, other people will continue to take them and they get paid
Definitely.
and you don't. So there was a letter from him. I was down in Mexico speaking on my series, my ideas, Colin,
Yeah.
and there was a letter from him saying he really enjoyed meeting with me, and he might want to use some of our ideas in a future column. And I'm going through, dude, this is past tense. We are not in the future here. And it was signed Cheers Art Bookwald, a very well-known person.
Also a
Um,
well-known person who got sued for copyright infringement.
oh my God, you've made my day.
Yeah. So it's one of those, and this is like a situation that will happen because what you're trying to do is you're seeing the best in people, and you're just like, oh, like a famous author has come down and talked to me, and just
Mhm.
they wouldn't dare take my ideas.
Yeah,
and and
we could. Well,
one of
that
those
wasn't even didn't even cross our mind.
cross
It
your
was a
mind.
cash.
Yeah.
It was a conversation. It turned out that Art had three teenagers. I had. I was president of a college foundation, I
Mm-hmm.
was hostessing just him and me at dinner. And before he gave a wonderful lecture at the college. And that and when you get two parents of teenagers of teenagers
Yeah.
collectively together, there is a lot of commiserating and they can go
Yeah.
on. And
Yeah.
my kids were a couple of years older, and I came up with a whole new concept idea of what we could do with teenagers in lieu of the draft.
Mm-hmm.
That's where, because I had a 19-year-old son,
Okay.
and that's how it all started. And I wanted, I said, let's take away their ability to drive a car for 2 years. I mean, let's just substitute this in, and we
Mm-hmm.
can save on grades. Grades will go up, sex will go down, accidents will go down, your insurance rates will go down. I had this laundry list of things, and we laughed and we had a fun evening. And then I saw the column when I was lecturing down in Mexico. Um, and that's when, oh, maybe I should start taking my ideas. I hadn't thought about, but I was well aware you couldn't trademark a book title, but I hadn't thought about, well, I didn't, because you know, I was never going to write a book. That's what catapulted me into
Mm-hmm.
writing,
Yeah.
taking, taking a class that I had been teaching on women and money for years and turning it into a book that did very well. But it was only a one book pony. I had no idea
That you
they'd
continue it.
live.
Yeah. Yeah. And
I,
it's like if you had your
no
first
one
book,
told
if
me
you
that.
yeah, if you had done that, then you could kind of, and that's what you do. You have a series because remember, it kind of goes into the idea of a trademark because a trademark is a source identifier, right? And that's like, so
Yeah.
see somebody see this. And so if you had started early with this and it was like the Judith Briles series or Judith Briles
Yeah.
Women Success for Women, and then you would have a subtitle with all
Mhm.
the others, you would have created that series of books and then you would have had that. And some people, you go to the airport bookstore and you say, oh, there's a new Judith Briles book, so you can go and grab it. And if you think
Right.
about that, there's series of books when you go and look at a bookstore or like it's like, oh, this is the series, and authors can do that series. Um,
Well, that's great information, Colin.
you
Actually,
know,
you really to take your name. If you're gonna, here I am working on book 49 and 50 at the same time right now.
hmm
um, that that will be out by the end of the year.
no,
Here's what you're doing, but a lot of us aren't thinking like that. But I will tell all of you, books do breed books. There rarely is a one book pony that comes
right,
along, so
right. It's
you might
good
want to
because
think about that.
it's like once you get the first one, you're off to the races because you understand. You've climbed the first big mountain, and then there's like, oh,
Yeah,
the next mountain isn't as hard
yeah,
because you're
yeah,
at a level.
yeah,
And
yeah,
for
yeah, yeah.
example, for
Yeah.
you have a podcast series, you have a series of books. Do you
Yeah.
speak? Those
Oh
could all be
yes,
under your name,
yes.
Judith Briles, and because it's you're
Well,
the trademark for.
okay, so let's talk about I mean, now we're talking about maybe, are you talking about a gazillion trademarks or one massive that you could come, that by
Well,
default they were coming, because this can get pretty expensive.
it can get expensive, but you can mitigate the costs. And so
Ooh,
what the trademark law does is, so you file one trademark application, but it's divided into
uh-huh.
different classes. And the
Okay.
reason why they divide it in classes is for sorting, because you need to have some index to go on. So
Hmm.
there's class 16, which is printed material, the books,
Mm-hmm.
periodicals.
Hmm.
Then you would have a class for consulting services. And so like if you're offering consulting services based on the book, that would be another class. And then probably one more, like podcasting, would probably be a different class. So that would be three classes. And what the Patent Trademark Office would say, well, you can file one application under the three classes. And like so you pay about, obviously government always gets tricky, but you pay between like $350 and $550 per class to the government.
Okay,
And
so
then, and
are
then
you limited, Colin? Are you limited to like claiming three classes under one trademark application?
no, you can file as many
Oh, you could
classes
do more.
as you want. But the important thing is with because of the Constitution, in the United States, you actually have to show use in each class that you're doing. So you have to submit a specimen saying like, okay, and then they give it. And then once you get that, what you're given is a nationwide right a monopoly to use that mark for those services. So it winds up being a very powerful and important asset for you. And it's also like, as we were talking about, an asset that can be brought down and to the family, like Dear Abby. Dear Abby, that's a mark, and it's like
I
it's gone
read
down
it
to yeah,
religiously. I read it
but
religiously. Yeah,
yeah, and it's the daughters are now doing it.
I know. Yeah.
So but they probably own the trademark for Dear Abby. So the only people who can use Dear Abby are the people who own the trademark, because you can assign trademarks down through to whomever you want.
And that's asset management. Okay. So
Yes.
here's what I can say to all of you listening in or watching. Man, oh man, I wish Colin had come into my life 40 years ago, because I was so ignorant for many, many, many years, really even understanding this. If when I had, like when I went in for the Book Shepherd, I have the Book Shepherd trademark. But I think what's really important is to understand that you need to put some real energy and thinking into this. And you need to have a team or someone like Colin on your team for certainly that you think about your overall branding. So, where is this baby going? Like I spoke, Colin, in all 50 states and 20 countries on my books over the years.
Yeah, and you probably what if you're a public speaker, you can
Hmm.
put something in the contract that, like, this is your work, it's your copyrighted work, do not copy.
Yep. Yep.
And because you think everybody's good, and most people are, but
No, they're
somebody,
not.
yep,
No,
somebody
they're
sees
not.
it, like, oh, Judith said something really, really cool. I'm going to take that and I'm going to use it myself. And whenever, if you're ever giving presentations and authors, you're going to give a presentation, put a copyright notice on anything that you're handing out, because
Thank you for saying that because I tell everybody to put a copyright notice at the bottom of every handout they put
yeah,
out. And,
yeah,
and let me just also, if those of you who are doing presentations and you're putting slides up or you're sharing slides, please put a copyright notice on every slide.
absolutely, because what they're gonna what if there's a situation
They'll rip you
you're
off. They're all
you're at
taking
a,
pictures.
yep, they're taking pictures, and then all of a sudden you see your work being used somewhere else. By having that copyright notice, they can't claim ignorance. They're like, you were in the room, you saw that. It's and they can't say, oh, I didn't know I wasn't allowed to do it. Well, it's right there, and that's the importance of the notice. And it is a funny thing, because, like, sometimes you'll be dealing with marketers, like, oh, that looks ugly on the page or everything like that. It's like,
I
put it
know.
on there. It's people are expecting to see it, and if you don't see it, then there's a potential that somebody's going to copy it, and it's a
That's right.
cheap and easy fix.
Right. So everyone, here's your little hacky poo that you
Yep.
do on everything you do. Just go in when you're in a Word document and you're working on it. All you have to do is go into your header footer thing. I always
Yep.
put it on the footer,
Yeah.
and you take a parens and the letter C and a parens, and there's your circle with the C on it. Get your year on it.
Yep.
I put the year and then I put my name on
Yep.
it.
Yep.
And then I have other stuff on that line too. But I just think it's really important, so critical. I'm so glad we're having this discussion, Colin. Um,
It's important, because people, they're like, oh, do I really have to do it? You do, because it's like there's a known that that somebody's going to copy your work, but you don't know
for
who it
sure,
is. So how do you
for
protect yourself?
sure.
You put it out there, you put it on notice. And another thing, what you're saying, that is kind of important for authors, and that they're having ideas and they're going to meet somebody. Uh, you have it's called a non-disclosure agreement. Like, if you have an idea, say you're having an idea for a book or even a script or something like that,
Mm-hmm.
and somebody says, oh, I would really love to talk to you about it. And it's like, okay,
Mm-hmm.
before I go and talk to you about it, sign this non-disclosure.
Mm-hmm. Well, or as everyone, if you follow politics, all it's called an NDA, right?
Yep, yep,
So on an NDA, because I do consulting, I work with people, I help them write their books. I
right,
do,
yeah,
whether it's branding sessions, actually writing, digging in
yep,
that I'm going to have to come in and rewrite a lot of your words and whatever it is. If they say, "Well, I'd like you to sign an NDA," of course. I mean,
Yep.
the last thing I do is have time to take other people's stuff. I do not have it.
Right.
Not in
Right.
my
And it's
bandwidth.
yeah, and it's also a good test too, because if you're working with somebody, it's like, I would like you
Mhm.
to sign an NDA. It's like, I don't want to sign an NDA. Well, that's a sign right there for you to kind of maybe move on.
Yeah. I have, I sometimes I'll say, and I will ask them, what's your concerns? And doing that. And then, I will go into detail. This is how we will work together.
Hmm.
And
Yeah.
I think also, for all of you who are working with other consultants in your books, in your writing in any way, that you make sure that you get copies back to you of whatever, because I work live with a lot of people, Colin, when I'm working with them,
Yeah.
and we're working on a Word document manuscript, and it's dated, and they immediately get it, immediately within,
Hmm.
before we sign off on Zoom, because we'll do a lot of this on Zoom if they're distance,
Yep.
that they get it, and I verify, did you get it in your email? I just want to, I verify that they have got it back and save it. And, I can't stress how important it is. Let me give you another thing you want to put a copyright on, everyone. Those of you who are using social media, and making posters and things, and whatever your sayings are, copyright it. Put the date, the year, the copyright symbol, your name. Just please do it.
Yeah. It's an easy thing to do, and it's important. And it also it because it's also kind of a shield for you, because the infringers will notice, like, oh, they're taking this seriously, and like, because if you actually do find somebody infringing on your copyright, then you can sue them. I mean, you have to go get a registration. This is the great thing. You have a Once you create a work, you have a copyright in it.
Well, and you brought
But
up something, one of the paths I wanted to go down with our conversation, because, I did have a major publisher after we ended our kind of, rights all came back to me, continued to sell my book without my knowledge. Foreign right. And I always say the name, it was McGraw-Hill, and continued to sell my book in Europe and stuff, and I never got a nickel. Never got a nickel. And it
so
was an accident on how I discovered it. I was doing some searching, and all of a sudden my book came up in French in Belgium. I'm going, what the hell?
but they had
And
they translated the book. They translated your book without your knowledge.
Yep, they did. They did.
Hmm.
They did all that. And I had, again, ignorant, that would be a capital I, would be across me,
No,
on what
innocent.
to
It's
do.
more
Yeah. Oh,
innocent because you
oh,
don't you,
thank
you
you.
don't you don't
Okay.
know. Yeah.
Yeah, I did
Yeah.
not know what I needed to know.
Yeah.
And I did consult with an attorney, for this thing. And the cost of file, it was clearly a copyright infringement.
Yeah.
Clearly. But the cost of going down that line with someone who has a deep pocket,
Right.
I didn't have their deep pocket. And what we and then getting all the accounting, because I've always said there is a lot of skullduggery in publishing. I was with 18 of my books were with traditional publishers. That Before I created my own imprint and said, I'm taking control. I'm just going to take
Yeah.
control here.
Yeah.
um, that that to get the data to show how many sales had really happened, I knew was not going to happen. To get the data to say what kind of revenues, I knew it was going to be, my gut told me you were not going to get this. And the cost to launch that kind of pace, I was looking at 50 to $100,000. I We just had
Yeah.
a
It's a possibility you would have filed, and then because the interesting is statutory damages, but that's the copyrights in Europe, whereas in the United States you have statutory damages, and it makes a lot more.
yeah.
They're under a little more pressure, because you can say, like, well, you sold X number of books, and that's all infringement. Did they use your image on the book covers?
Use my name.
Username? Yeah. Sometimes there's a picture in the back. Is like, because that's your right of publicity.
And
It's
I have to go find that. I mean, a friend in Canada bought the book, so I could and sent it to me,
yeah,
so I had it.
yeah.
But it just blew me away. It blew me away.
And this is another thing that's kind of important for writers. because you're so excited. You got a publishing contract, right? And you look at it and you're like, well, remember they wrote the contract
For
and
their benefit.
it's for their benefit.
Yeah.
And then, but there's nothing wrong with you kind of coming back and saying like, well, I've looked it over and here are all the changes. And that's why it's important. So like, it, if you're an author and you got an offer to publish you need to go talk to an attorney. You need, and it doesn't have to be an IP attorney. It could be a contracts attorney, because somebody you know, because it's a contract, and because probably in the original contract it said that we're going to pay you royalties for all writings in the United States, all sales in the United States. McGraw-Hill has right to distribute the book globally. And it was probably on page 15 of the agreement in like paragraph 3. And because you're not thinking
I was to
that,
get 50%. Well, no, it's buried and you get 50%. And if there's movie rights or 50, that actually pretty standard. But I think what you said is so important. They're written for the publisher's benefit, not yours.
Yeah.
And even though I had agents involved in all this, the little that they do in tweaking is really minor. I think that's if I was ever to get involved with a traditional type of publishing contract, again, I would have IP and contracts attorneys going through that. But this is the older self talking to the younger self.
Right. Well, isn't that it's like all advice is to people realizing their mistakes and trying to help the next generation along. This is what you need to be thinking about, and it's because if you know that their best interest or that contract is all in their best interests, not in your best interest. And here's the thing: it's like if they really want you, they'll agree to the contract changes. Because if they think your book is going to make them a lot of money, and you say like, I'm not going to sign this contract with you because of this, this, and this, and like I won't do it until you change it. They really want you. You know what they'll do? They'll change it.
Yeah. Well, Colin, you've worked with authors, you work with people with all kinds of product tied in there. Your ego is being lured when you get into some of these contracts, and you're so excited to be represented. I was with Simon Schuster for many, many years. McGraw-Hill pulled me away to do that, and that became the bridge that I'm
well,
gonna do
it feels great, right? Like a major publisher is publishing my works. It's like a life achievement. It's very few people get to that level, and then you think once you get to that level, they'll be kind of your partner. But there's slightly your partner, but there's slightly also your adversary at the same time.
Yeah.
So.
And the data for all you now that when I started 40 years ago, there were certainly less books being published. And there wasn't even the only thing self-published was the Vanity Press, which was Gagne. That I am a recovered New York snob, Colin. But I thought that was and that was the only way to be represented by a major. But the reality is, with over 2 million books being published a year now, only 10,000 or less come out of the traditional web.
Well, that's amazing, right?
So much has changed. The quality of what we can do, the help we can do, and what you have to do for all of you is the moment you start writing, you got to think about your branding, and you need to think about, okay, marketing. Here we go.
Your branding, your marketing, your protection. And
here we go.
Another interesting thing that people should be really focused on is sometimes if they're writing books and they have photos in the books, and so say or like, oh, I want a book cover, and so they'll pay a photographer to take the picture of uses the book cover. Yeah. What you need to do is have a work for hire agreement. So people think it's like, oh, if I pay somebody to take a picture for me, I own that picture and I own all the rights to the picture. You don't. You just own the picture. So what you need to do is when you're dealing with like any pictures, or if you're having somebody create a website for you, you make sure there's a work for hire agreement, which means they do the work for you and they sign all the moral rights back to you so that you own it going forward. and
Mhm.
it's another one of those like tests when you're dealing with people. Do you have a work for hire agreement? And they're like, I don't do work for hire agreements. Well, then maybe you shouldn't work with those people because
Mhm.
if they're
Mhm.
professionals, they're like, yeah, of course you're going to have a work for hire agreement, and
Yeah,
we're going to.
and so imagery is really important to talk about because if you're going to if you want to put it on mugs, or
Yeah,
t-shirts, or
yeah,
my God, let's put a tattoo across your chest, right? So
yeah, yeah, yeah. Right, right. You
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 want to
you you
be
want
able to
you
have
want
the
that
ability
protected.
to do that. Yeah.
Yeah,
Yeah.
and
You want to.
and it's one of those things people sometimes don't realize. And it's like, oh, like look at this beautiful. The great example is like the Marilyn Monroe photo where she's on the grave.
Oh, yep. And the dress is going up. Yeah.
The dress is coming up. Um, so somebody paid that photographer to take that photo, but he had the rights going forward because there was no agreement. So then he made a fortune off it because he owned the rights to reproduce the image. And so that's why it's important that like if you're doing anything like that to get it kind of signed over. And it's also situations where if you have a designer, like you said, if somebody's designing a logo for your book or anything like that, make sure there's a work for hire agreement and make sure that you own all those rights going forward.
Mm, absolutely. Well, listen, we're actually halfway through, but I have some questions we want to get
Okay,
into.
great,
This
great.
is fun. I love chatting with you. When you started in law, did you always know that you were going to go towards intellectual property?
No, actually not. It's kind of a funny story. So
Yeah.
I was born in Ireland and I came to America and I was the first one in my family to ever graduate college. And then I was like, well, maybe I want to go to law school. So like you climb one mountain, it's like maybe climb another. And I was working at one firm and it was an antitrust firm. I didn't really like it. And I was like, well, maybe law isn't for me. But I was like, well, let me give it one more chance. And so I put my resume out there and I applied to this firm and the guy said, come in and talk to me. And his name was Mac Webner, and he was like one of my first mentors. And he sat down and we're across the table, and it's like, so he said, Colin, do you like Elvis? I was like, yeah, I like Elvis. Yeah. He's like, well, I represent Elvis Presley. And I was like, but Elvis is dead. And Mac goes like, but not in the trademark world, because he was the person that represented Elvis Presley Enterprises, which has all the trademarks for Elvis, the Elvis
Wowza.
likeness. Yeah,
Wowza.
and so and that Elvis Presley Enterprises is Priscilla's company,
Yes.
and so
She was an amazing guide.
yeah, yeah. And what's really interesting because you know the story about Elvis where like was it Colonel Tom Parker stole all his like songs and everything like that, but they were able to kind of his likeness, his images, and so they were able to kind of monetize his life, the Elvis Presley estates, and his family were able to make money as a result of creating IP around Elvis, his likeness, and and so they might have lost the rights in the music, but they kept all this other things, and it made it transformative wealth for the family going forward, and it's in a trust. And I was just
Mhm.
thought I was like, wow, that's amazing. Like you're helping the family who were kind of, you know, they were kind of, they weren't treated
They
right
got
by people.
shafted.
They
They
got
got
shafted. I'm
shafted.
gonna try to be polite, yeah, but they got shafted
Don't be polite.
and they got screwed over. And
Yes.
but they had some smart people come out and let's figure out what we can do to this to help you and
Yes.
monetize going forward. And that was like, oh, this is really really kind of cool. And so I started working with him, and then I was like, yeah, this is the area of law that I want to go into. And I went to law school, and I was
Hmm.
working at a very large firm that only does trademarks and copyrights, and then corner office partner spun off. I joined him, and I've been doing it for 20 years and like protecting like big brands, like Fortune 10 brands, but I'm also helping startups. And the startups are exciting because sometimes you're with a small company, and then over the course, they might have like $100,000 in sales, and then 15 years later they have $50 million. It's kind of, and you kind of you go along the journey with them. I was like, okay, you start here and then you kind of keep on going out. And it's nice as you're doing it, you're protecting them as you go forward. It's like, okay, like, oh, we want to go
Well,
to Japan. Okay, let's protect in Japan. So
yeah, well, and I think if you bring this kind of in your awareness screen, everybody, that this is part of your branding going
yes,
forward,
yeah,
um,
yeah,
that I think it would make a huge difference in your success model. because there are things that you can do today that certainly did not exist when I started down this path. A
Yeah.
book was a book. Book was a
Book was a
book,
book,
and
right? Yeah.
yeah, and maybe a movie might come from it.
Right.
But it that's a fun story. I love the Elvis story. In doing that. So let's jump in. You had said too there was a who and what question when it comes to trademarks. So what are the who and what questions?
Yeah. So this is actually a kind of a fun exercise. Okay.
Okay.
What is a mode of transportation? What has four wheels? Uh, what uses gasoline? And what is, what does most every family in the United States have? What is that?
Okay. Oh, well, you're going to say a car, but there's something else you're going to tell me.
No, it's a car.
Oh, it is a car.
That's the
Okay.
what. That's the what. All right, so now let's go to the who. Okay, so who is Italian, red, fast, sexy, expensive?
But Ferrari.
A Ferrari, right? So that's the who what dichotomy. So what is a Ferrari? It's a car. But who is Ferrari? It's red, expensive, sexy, fast. And that's what the trademark is. It's the trademark is yes, a Ferrari is a car. That's what it is. But who Ferrari is are all these. And that's the brand, and that's the brand value.
Oh, I love this. This is a great exercise.
Yeah, and so any author can think about this. It's like okay, so you can say you are a writer, a lecturer, an expert in women's leadership. But then you can kind of change it. It's like, I'm a well-known podcaster. I'm a mentor, and you have all those, and that's who you are, and that's your brand. And
So
so,
now it comes back to, boy, I think, and this is now, ooh, let's kiss on AI a little bit here, Colin. I actually I pulled it out. A current issue of Time magazine is the it's a whole section called the People versus AI, and it's in the March 9th. So last month.
okay, yeah,
Okay, March 9th. The People versus AI. I said, I have to read this again. I need to chew over this again. So I, pulled it out.
yeah, yeah, yeah.
Uh, I'm done with the rest of the magazine. And I've told several people about it because this is into the who. And now we're packing in the branding. For authors, I have said when they have their pen name, so you're going to create another brand. Okay. So this exercise is a great exercise for everyone to go through that what is, but now the who,
Ooh, yeah,
like, you know, who is known as the book shepherd? It's
right.
me.
That's you.
Okay.
Yeah,
So,
yeah.
so what you have to do is really think, I think people need to be expanding of the who is you and what are those components, those unique
Yep.
elements that really says, oh, that's the person. That's the go-to, that's the go-to person.
Right, right. And
Mm.
and because what you're trying to do is it's like a trademark is considered like a mental shortcut. And so somebody like in the publishing and the book writing says the book shepherd, like book shepherd, oh, that is Judith Briles. I know she does all this stuff. And that's a trademark because it's a mental shortcut. Once they hear those three words together or they see those three words together, like, I know who that is.
So if one was to trademark their name, because
Yep.
I was listening to all the scary stuff that's now, and I'm going to kiss back to AI. All these phony videos that have ripped off the likeness of people or pulled them from clips and
Yeah.
picked up their voice. It is so.
It's crazy. It's and there's
What's
another
going to
concept.
happen here?
It's called a right of publicity. And
The right of
it's a right of publicity, and it was a law that was this concept of law that was actually created a little bit later. Like trademarks, copyrights, and patents have been around a really, really long time, but it started at like the late 19th century, early 20th century. There's the concept of like, well, somebody's likeness is very important, and you shouldn't use people's likeness. And it's actually kind of it's a more state-based law. So uh, there's like Illinois has a right of publicity law, California has a right of publicity law. And the interesting things about these different states is that the right to use the image and likeness of a person can extend beyond their death. But it's patchwork. So like if you died in California, I believe it's pretty far back. I mean, it was like 75 years after the death, you still use the likenesses. And I don't quote me on that, but but in other states, it's like 25 years. But
Okay.
it's one of those things where if you're using your image and people, you have a right to your image, and then your successors have a right for a certain amount of time to protect the image of them. And it's fair, right? Because think about this, like they're violating your right of publicity if they're using your image on something. It's like, well, that's me. You're not entitled to do that. You're entitled to your own personhood.
Okay,
And
but Colin, this is what's happening. These people are
yeah,
not even dead. They're, I was watching something, I can't remember. And finally I thought, God, I wish there were telltale signs early on that this is a fake. So you don't invest a bunch of
yeah,
this was a video with a
yeah,
well-known personality.
yeah. They did.
And
Was it the Tom Cruise in the first one where they kind of copied him and just
oh,
yeah.
the Tom Cruise and somebody else. I can't remember what it was, but
Well,
it
with
was
Brad Pitt,
BS.
then they were fighting with each other, right, on the video. Yeah,
Oh, oh my God, you've seen it too.
yeah,
Okay,
yeah,
so
yeah.
Tom Cruise is a living person. Brad Pitt is a living person. What
They
do
can
they do?
sue. They can sue for right. They said take that down. You're not using my likeness like this. And you know what they're doing. The AI companies is most technology they race ahead of the law, and they say that then they ask for forgiveness, not permission. But
Mhm.
you know they're on kind of shaky ground right now because like the Constitution of the United States has this clause, and I'm just going to read it to you. It's like it's to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to the respective writings and discoveries. That's in the
Ooh,
Constitution.
which part of the Constitution? I want to know.
That is Article 1, Section 8, Clause 8. And it's
Order
the intellectual
one,
property clause. Yeah.
Section
Article 1,
8,
Clause 8.
clause. Thank you very section 1,
No,
clause 8.
Article 1, Section 8, Clause 8.
Oh, got it.
And
Thank
so
you.
it's interesting to promote the science, how language changes, to promote the progress of science and useful arts. Um, Useful arts back then meant inventions, and science meant knowledge, and like any writing and everything like that. But it's kind of flipped. So like you think arts now, you think is like writing and photography and dance, but that would be viewed as science back in the day.
Hmm.
But
Hmm.
this is in the Constitution. There's no real way for them to get around it. And like as you know, there's like tons of cases that are going on, and they're trying to they're saying like, oh, we're entitled to do all this, but at a certain point in time, there's about 89 cases going on right now, and different people are suing, and you're in discovery phase, and their arguments like, well, it's fair use, and well, are you using for educational purposes or no? And
No,
it's
I'm
interesting.
using it to monetize so I get money.
Monetize.
That's
Well,
what they're doing it for.
the interesting thing, OpenAI, the first company, they started off as a non-profit, and they're
I
claiming
know.
remember they're going to claim we're doing it for the betterment of mankind to do this, because they knew that they were going to, if they start monetizing this, they're going to run into copyright infringement grounds, and
So
they're
do you think
protect.
that's why Colin, is that why Anthropic settled so quickly that $1.5 billion
I do. I
amount?
think it's there's a lot of stuff going. They just took stuff. All these companies just took stuff, and they stole it. And then
Mhm.
and so if you had done a license with a company, saying we're going to license all your images to use this, that's fine. Well, that's not fine because the creator is going to be upset by it, but at least it's legal. They were just kind of like, we're just going to take it, and like, well, oh, sorry, too late. But like I said, it's in the Constitution. It's not like you have, if you go, it's going to probably take 1 to maybe 4 years to kind of work its way up. There hasn't been So when you file this kind of like inside legal baseball, you file in the district courts. They're all the lower courts, and sometimes they issue a decision one way, and then it goes up to the appellate courts. And the appellate courts were usually where you get more of a robust decision and discussion of the law. And if there's a question between the different appellate courts, it goes to the Supreme Court, and then the Supreme Court ultimately decides. Now, the current makeup of the Supreme Court. Sonny Sotomayor was a former intellectual property attorney. Neil Gorsuch and Kavanaugh and Roberts are strict constructionists. They you look to the words of the Constitution, and I don't see how these AI companies are going to get around that, because I could see Gorsuch says it says right here in the Constitution that they're entitled to a monopoly. Did you pay them? No. Well, did you take it? Did you have a license? Like, no. So they're facing a potentially massive liability.
So when is the doo-doo going to hit the fan? Literally, and running through that, because that's what there's Colin, there are so many scams floating around that list the likenesses of well-known personalities or the work of well-known for the only purpose is to put money in their pocket.
And the pockets,
whether they're in Nigeria or Timbuktu, right? Or in Duluth. It doesn't matter where they are. That's what's going on.
It's so frustrating, and I think if I put on my Nostradamus hat, I think we're going to have something in a major decision in 2027.
2027, major decision.
2027, yeah.
I'm going to hold you to that. We're coming back for another show.
Yeah. We're coming back for another show. We can discuss the case and what happened with it. But there's going to be circuit splits, and that means so the California's in the Ninth Circuit, and they're more creator friendly, which makes sense because
it's in California.
It's in California. Well, especially like Southern California, like Northern California, they're the ones who are stealing all this stuff, and Southern California, the ones who are kind of creating all this stuff. And then there might be like the circuit in Texas could be a little bit more like the AI companies. And so when that happens, it'll probably be called a circuit split, and then that goes up to the Supreme Court, and it's going to be one of those fundamental decisions that that's going to affect lives going forward. It's because I just think it's in the Constitution. You're going to have to figure out something, and it's sometimes there might be a law that's passed because remember in the late 90s when the web browsers started coming out and you could search, and also all these images were there, and people were saying, well, that's infringing, take it down, or like they would start suing the websites, everything like that. So Congress created what is called the Digital Millennium Copyright Act, and what they said is like all these web pages and everything like that are like kind of view them as trains, trains going across the country, freight trains going across the country, and they say we don't know what's in the freight cars. Does that make sense? So they don't know in the freight cars, but if somebody says like, oh, in that freight car right there, there's copyrighted material, and so what they would do is they would just delete it. They would push it off. Okay, and so then they got liability. They got safe harbor from liability, so they couldn't be sued for copyright infringement as long as they follow the terms of the DMCA. And most web pages now have this. It's like a DMCA. It's okay. If you think somebody's your copyright is being violated, you can reach out to us and we'll remove it from our website.
There was something that Colin, I know we're going to start. Oh my God, we've got a couple of minutes left. That came. Obviously, going to have to do another show if we can do that. But
that'll be great.
All right, that Amazon came up with, dealing with, I think, DMT. The digital management that they have, that you sign a deal and they said, okay, forward, we're taking, you have to come back and reconfirm, because I've always said, yep, I want that. I want to be in that, all that stuff.
Yes, definitely. Yeah, because Amazon does a really good job of protecting they have a process. Like if you have trademark, it's an Amazon brand register, and then you're become a
Yep.
brand register. And for writers, they have the same thing. They will kick things off if you're a part of the if you're part of their program, because it makes it easier for them. I mean, Amazon's so huge, right? They have like billions
Yeah.
of transactions, but if you follow their procedure, then they can
Yep.
like, okay, take it off, take it off, take it off.
Yep. 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 And they certainly and they all ask now, did you use AI at all? And I have almost myopically stayed away from it because I just don't want to get pulled into the path.
Well, it's AI can be a very useful tool for
Yes.
writers, but this is
Hmm.
really important. And so I know we're running real low on time,
Yeah.
but if you're
Give me one
using
minute.
if you're using AI for anything, make sure your settings are set up that none of your writing is used for training purposes. That you go into the settings and make sure that it's not there. And so my wife, who wrote her book, like navigating technology, she was like, well, should I use AI? And we looked at it, it's like, well, very, very important to kind of file this thing that you do not allow anything you're using on AI to be used for training purposes. It's only for
Well,
you.
well, it's not only that, which is yes, definitely. And the
Yeah,
Authors Guild has some really good programs. I'm involved with the Authors Guild, and
yeah.
they actually do human certification for your books now. But you can't, that they need to understand the difference between AI generated versus AI assisted. And that you can't, if you're going in there saying, hey, I have this idea and help me write this, and I want to write it like, James Patterson,
Prompts.
and I
Yeah,
want
using the prompts. Yeah,
to, boy,
yeah.
you cannot copyright that.
No, no, no.
You
It's
cannot copyright that.
the
All
Copyright
right.
Office has been really strict with that stuff.
I know. So we've got to jump ship. Colin, we're gonna come back and redo another show. We have to do that, but you can find him at llflegal.com.
.com.
That's
Yep,
LLF as in Frank,
yep,
legal.com. And his email is CO Brian, like
yep.
Colin, he is an Irishman. Colin
I am an
O'Brien
Irishman.
with one L. And at llflegal.com. Thank you so much.
Thank
Thank
you.
you
This was a
so much.
wonderful
I love this
conversation, and
show.
I really appreciate getting to talk with like creatives like you. It's because
Yeah,
it's so hard what you do, and it's so impressive what you do,
yeah,
and I
it
really
is.
I thank you for the opportunity to talk to you. It was been really, really fun.
You are so welcome. I will call you to set up and we'll do a part two.
Sounds
Okay?
great. Okay.
All
Okay.
right.
Bye,
All right,
Judith.
everyone. Happy writing. We'll see you next week.